and the role of the courts in saying what the law is rather than what they wish it would be. Like the national organization, the Villanova chapter of the Federalist Society does not take positions on legal or policy issues, nor do we engage in other forms of political advocacy. Instead, we're about ideas, as you'll see today. And the executive board of the Villanova chapter of the Federalist Society consists of conservatives, libertarians, and other individuals who believe in limited government, but otherwise hold very conflicting views on a broad range of issues. Before I introduce our speaker, I do want to take the time to make a very special announcement. Thanks to Michael Leminski, it is my great pleasure to announce that the final Federalist Society event of the year will take place next Tuesday, so April 3rd, I guess technically this coming Tuesday, I guess. So April 3rd at noon in room 102, where we will, we're very excited to host Professor Richard Duncan of Nebraska Law, and our very own Dean Alexander will also be joining us for a very special event focused on the Electoral College. So Professor Duncan will be here to argue that despite the Electoral College's past potentially controversial results, such as Bush v. Gore, latest election, the Electoral College is more important to our system of federalism than ever before. His basic argument is going to be that in such a large and diverse country, the college itself gives power to all states, big and small, whereas a popular vote would render only a few large states important. And this shift, he's going to argue, would hurt the power of individual states and therefore our valued system of federalism. Dean Alexander will probably not agree. So, we hope that you guys are going to join us on Tuesday. Again, that's at noon in room 102. We're going to serve you guys food, per usual. Now for our event today. We are, again, very happy to welcome Professor Josh Blackman, an associate professor at the South Texas College of Law in Houston. Professor Blackman specializes in constitutional law, the U.S. Supreme Court, and the intersection of law and technology. He's the author of several critically acclaimed books, including Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. It's almost like you know something about health law.
You think,
it's a weird thing. So he has also authored over 36 law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, Washington Post, USA Today, LA Times, and other fake news organizations. Professor, sorry. I'm only kidding. I'm totally kidding. Professor Blackman was selected by Forbes magazine. That's real news, right? Yeah. So, selected by Forbes magazine for the 30 under 30 in law and policy. And he has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and health care. Today, Villanova University Charles Widger School of Law is very lucky to have him here speak on the intersection of bioethics and the Constitution at the Supreme Court of the United States. I'd like everyone to welcome Professor Josh Blackman.
Thank you so much. This is my first time at Villanova. I've been to Penn, I've been to Drexel, I've been to Rutgers Camden. You guys have been holding out, but no longer. Thank you much to the Federal Society and the Health Law Society for hosting me. The topic today is bioethics and the Supreme Court. But it's even broader than that. Throughout the past 200 years, our Constitution has intersected with many aspects of bioethics, and in particular, how the law treats the human body. So my talk today will walk you through this history from the text of the Constitution, to slavery, to eugenics, to abortion, to assisted suicide, and beyond. So our story begins, and it really must begin, with the very Constitution itself. And a provision that I'm sure many of you are familiar with, which is the 3/5 compromise. Many people don't actually understand what this compromise did. Everyone says, well, for purposes of the Constitution, certain people only were a fraction of others. That's an important statement of bioethics, to say that one person doesn't count as a full person, but only as a mere fraction of a person. So let me read the provision to you. It says, Article 1, Section 2. Representatives and direct taxes shall be apportioned among the several states according to the respective numbers, which will be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. So there are two dynamics going on there. The first dynamic is representation. Slaves would only count for 3/5 of a person when you're counting how many representatives the state gets. So, controversy right now, the census, right? Ooh, that's new. So there's an issue with the census. If you diminish the number of non-citizens counted in the census, you decrease the representation of certain states with more citizens. A similar dynamic plays here. If you only count a fraction of the slaves, states with a high slave population would have less representation in Congress. Wait a minute, Josh. So what you're telling me is the 3/5 compromise actually diminished the voting power of the South? That's exactly right. What most people don't understand is the Southerners wanted their slaves to count 100%. Why? That would have given them more votes in Congress, and thus more votes in the Electoral College, the topic for next week. The Northerners didn't want to count the slaves at all. Because if the slaves were counted, the South would have more power and could keep slavery laws in effect for some time to come. So the compromise was actually backwards than what you thought. It was the Northerners who wanted to diminish them down to 0 for purposes of the Constitution. And the Southerners wanted to count for everything. Now, they wouldn't be able to vote. They would exist only to enhance the voting power of the South. It also affected taxation. The Southerners didn't want to have to pay taxes on their slaves. The Northerners did. Let them contribute more money to the Union. So this number 3/5, right, 3/5, 60% was pegged to ensure that the South's voting power would be held in check, but that if they were counted for voting, they would also be taxed. Taxes never made it. We never really had much of a head tax, what we call a capitation tax. But the compromise of the 3/5 for voting mattered. It's no wonder that almost all the early presidents were Southerners, with the exception of John Adams. Why? Because they had a boost in the Electoral College based on the number of slaves. And had the slaves counted as a full 100% of a person, slavery may have existed much longer in a republic than it ultimately did. I'll give you a very concrete example. The Constitution protected what's called the Fugitive Slave Clause, right? That you could have, the slave trade clause. You can have slaves brought in from other countries. And it said you can't ban this till 1808. Indeed, in 1808, Congress banned the slave trade. Had the South had greater representation, it's possible that slave trade would not have been banned. And I don't know how that would have changed the fate of history. So, from the very beginning, we had this sense of how much a person counts for directly impacts not only representation, but the policies created. And the sad truth of this is that none of these people could vote anyway. So no matter how they were counted, they were not given any representation. The next provision of the Constitution I'd like to talk about is what's called the Fugitive Slave Clause. This provision addressed a problem. We're in Pennsylvania, perfect place to talk about it. Have any of you ever driven from Maryland through Pennsylvania and you see a sign that says you're now crossing the Mason-Dixie line? Okay. If you go the other way, right, from Pennsylvania south to Maryland, do you see that sign? No. See, you guys can be proud, right? Pennsylvania can be proud that this was an abolitionist state from the very beginning. Maryland, right, this little kind of weird-shaped state, right, on the border, was a slaveholding state till the bitter end, even during the Civil War. So what would happen if a slave managed to cross the border, the Mason-Dixie line, right, from Maryland to Pennsylvania? Under the provisions of the Fugitive Slave Clause, there was an obligation to return the slave, right? That he shall be delivered upon a claim of the party to whom such service may be due. Now, if you notice, the Constitution does not use the word slave. It was very deliberate. The framers were very attentive to this. They used phrases like other persons, a person held to service or labor. They were trying to avoid the dilemma of slavery by not referring to it. But by not referring to it, they made a conscious choice, such that abolitionists like Lysander Spooner and otherwise said, look, the Constitution doesn't even say slavery. Slavery cannot be supported by the Constitution. But this is a clause that's an example. And then we have the Fifth Amendment, ratified in 1791. It says, no person shall be deprived of life, liberty, or property without the due process of law. Notice it says no person. It doesn't say no citizen. It doesn't say no free person. It doesn't say no person except slaves. It says no person. Does this provision speak to slavery? Now, you may say, wait a minute. A person who is captured and kidnapped and put in chains, has that person been given the due process of law? Has he then been deprived of his liberty? The flip side, and what the Southerners argued, is that a slave was a property, a chattel, if you will, and that for the government to take away my slaves was in fact the deprivation of their property interest without the due process of law. So it's a bizarre argument that the exact same Fifth Amendment, depending who you are, looks very differently. Abraham Lincoln would often say that the phrase liberty means different things to different people. So imagine this, right? You're a sheep, and a wolf is attacking you. And your shepherd comes along and saves you from that wolf. You will call your shepherd your liberator. Okay? Now you're the wolf, and you're hungry, and you want to eat some sheep. And this shepherd comes along and knocks you away. The shepherd is your tyrant. The exact same position, depending where you sit, yields a very different result. And these are the early struggles over slavery and liberty within the Fifth Amendment. The first case I want to discuss is called Prigg versus Pennsylvania. Oh, God, this is perfect, Pennsylvania. You're going to love this, right? I can be a good Pennsylvania. I actually went to Penn State, so I do have a strong connection. I was clerked in Johnstown for 2 years, so I'm very... Anyone from Johnstown? Western PA? Anyone from Western State College? Where?
Johnstown, right?
No way! My friend. Okay, great. So, Prigg versus Pennsylvania involved a challenge to the Fugitive Slave Act. And here's how it worked. Pennsylvania was an abolitionist state. They thought that slavery was immoral. But you had this federal law, the Fugitive Slave Act, which said if any slave runs from Maryland to Pennsylvania, you have an obligation to return them back home. Okay? So Pennsylvania passed a law that says, okay, if you are a slave catcher, that was a profession back. You ever see the movie 12 Years a Slave? If you were a slave catcher, you need to apply to a judge in Pennsylvania to seek a warrant to arrest a slave. And if you arrest a slave without going to a judge first, guess what? You're guilty of kidnapping. Yes, remember that from Torts, right? Kidnapping. False imprisonment. So you have Mr. Prigg. Prigg was sent from Maryland to Pennsylvania to arrest a slave. He arrested him without seeking a warrant from a Pennsylvania judge. After some wrangling, he was indicted in a Pennsylvania court. And the Pennsylvania court held that he violated state law for failing to seek the warrant before arresting and kidnapping the slave. This case goes to the Supreme Court of the United States. And the U.S. Supreme Court reverses the Pennsylvania Supreme Court. And they hold that Pennsylvania cannot interfere with the enforcement of the Fugitive Slave Act. That the Fugitive Slave Act was a proper exercise of federal power, and the abolitionists could not interfere with it. And this imposition of a warrant requirement was not justified. So with that, the court reversed Prigg's conviction. Now, I'm sure you've all heard of Dred Scott, right? Everyone heard of Dred Scott. How many have heard of Prigg? No, 2, 3 hands. This case was far worse for slavery than was Dred Scott. By the time we got to Dred Scott, we were a few years away from the Civil War. Stuff was already pretty bad. It didn't have a significant legal consequence. But Prigg opened up fugitive slave rendition in every state, right? There was a fear that if Pennsylvania won, then you'd have this massive torrent, the Underground Railroad, that would just free all the slaves. But this decision said, no, you can't do that. These so-called personal liberty laws, which Pennsylvania had, Massachusetts had, could no longer be enforced. This decision also allowed slave owners to freely bring their slaves to northern territories and not have them liberated. Right? That if you owned a slave, you could say, I'm going to Pennsylvania for the weekend. I'm bringing my slave with me, and they can't take him away from me. This decision was far more significant. Right? It was authored by Justice Joseph Story, who generally is a well-respected guy. He's not held in the same sort of shame as is Roger Taney. But this decision had a significant impact. Now, one aspect that was not discussed, did the Fugitive Slave Act deprive a slave of his liberty without the due process of law? The court did not even address that question. The next case I'd like to discuss is one I'm sure you all read in common law, but perhaps don't quite understand. It was a long case. Dred Scott versus Sanford. Now, I stress Sanford. That wasn't his real name. His name was actually Sanford, without the D. But they misspelled it in the transcript, and that's how it is. So it's Dred Scott. You know, there's no blue book back then, right? Dred Scott, and this is John Sanford, who was owner. So this case presents a very important question in a bizarre context. Okay? You all remember from civil procedure the concept of diversity jurisdiction, right? 1331, I need to remind you, right? Diversity jurisdiction. A person from Missouri, a citizen from Missouri sues a citizen from New York, you get to federal court. You also know about federal question jurisdiction. What you might not know is that wasn't really a thing until the 1870s or 80s, after the Civil War. It existed briefly in the early years of the Republic, but they got rid of it. So for much of the Republic, the only way to get your butt into federal court was through diversity of citizenship. So what happened? Dred Scott sued Sanford in federal court. Sanford was a citizen of New York, no doubt about it. Dred Scott said, hey, I'm a citizen of Missouri. So you see what's going on here, right? The case was about a diversity lawsuit, but it required the resolution, was Dred Scott a citizen of Missouri? Was he a citizen of the United States? Or was he a mere chattel? The case presented a second question. Dred Scott's master took him north from Missouri towards present-day Minnesota, what was then called the Wisconsin Territories. Congress had declared the Wisconsin Territories are not slave territories, they're free. So by virtue of bringing the slave north, did that work in emancipation? Right? Did that free Scott? So this case goes to the Supreme Court. By the way, this is Dred Scott and his wife Harriet. And this is Fort Snelling in present Minneapolis, where they were held. So the first question for the court: was there diversity of citizenship? So the opinion was by Chief Justice Roger Taney. Okay, and this is probably the more hated opinions in the Supreme Court's case law. It's called the anti-canon. You have the canon and the anti-canon, right? If you're in a case citing Dred Scott, you're probably doing something quite wrong. Lawyers do cite it occasionally. There is some actual law there that's relevant, but probably not a good case to cite. So first, Taney explains that Scott could not be a citizen of any state because he was a slave. And he reasons this based on the fact that at the time of the founding, slaves were subject to the Fugitive Slave Clause. They were subject to the slave trade. They were counted in 3/5. All the various textual things I discussed earlier. He also said that slaves couldn't vote. They couldn't hold property. They can do various things. But then he goes a little bit further. He says, not only are slaves not citizens, but freedmen, that is, free people of African descent, are also not citizens. Now, here, Taney goes off the rails. Because at the time of the founding, if you were a free person of African descent, you had significant rights. Perhaps not as much rights as a white landowning man. For the matter, women had that many rights either. But at the time, there were a number of states that granted the right to vote to freedmen. They granted the right to own property. So as a matter of history, Tawney was frankly off the map. But why was he so adamant that people of African descent could never be citizens? Because if you were a citizen, you got certain rights. You were protected by what's called the Privileges and Immunities Clause, Article 4. Not the 14th Amendment, Article 4. Because if you were a citizen, you got a bunch of rights. So Tawney was very deliberate in insisting that because they're not citizens, they can't get these rights. If they had those rights, slavery would arguably be unconstitutional. So again, the essence of who a person was helped define what rights they had. Then Tawney went further off the rails. Congress had, again, established that in what's called the Wisconsin Territory. Basically, anything north of this, this line is called the Missouri Compromise line. Anything north of that line would be a free soil state, that there'd be no slavery. Tawney actually held that Congress could not do this. That Congress lacked the power to declare free territories. Why? The Due Process Clause of the Fifth Amendment. He said to free a person slave constitutes a deprivation of their property rights without due process of law. And guess what? It's a taking of property without just compensation. That to free a slave was to seize a slave owner's property without giving compensation. This was the exact argument I raised to you earlier. And this was a fairly, Tawney didn't make this up. This is what later became known as substantive due process. Tawney didn't make it up. It was known for quite some time. Okay? The decision in Dred Scott was 7-2. This is a photo of the court. Justice Curtis dissented. And he wrote that the Constitution was not made exclusively for the white race. And he said when that document was ratified, people of African descent can be citizens in at least 5 states. So at the time, Tawney's thought was not unanimous. In a separate dissent, Justice McLean wrote, quote, "A slave is not a mere chattel. He bears the impress of his maker and is amenable to the laws of God and man." Justice Curtis was so incensed by this opinion, he actually resigned from the court. He couldn't even deal with it anymore. Right? He goes to Tawney. Right? He was out. Now, as a historical matter, the Dred Scott case may well have contributed to the Civil War. Northerners feared that this was a mere stepping stone to the courts protecting Southerners and taking their slaves into free states. Okay? But our Constitution would make a turn in the other direction following the Civil War to start creating and protecting people regardless of their status, or at least in part. Dred Scott was never reversed by the Supreme Court. It was reversed by the 13th Amendment, which provides neither slavery nor involuntary servitude, except as a punishment for crime, shall exist within the United States. This recognized a very basic tenet of the human body. No one can own someone else. There is no slavery or involuntary servitude. That if someone wants to help someone else out, it must be on arm's length agreement, a contract, a lease, a wage, whatever it happens to be. This is a very basic principle. But does this mean you have complete autonomy from the government control over your body? We'll come back to this in a minute with eugenics. And then we have the ratification of the 14th Amendment. And Section 1 of the 14th Amendment, which you can all read in your snazzy constitutions, right, makes it very clear that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. By virtue of birth, you are a citizen. It is now your birthright. Conversely, the citizenship applies to the unborn. People still in the womb, are they citizens? We'll come back to this a little bit later. And then we have the Due Process Clause. The Fifth Amendment only ensured the federal government could not deprive people of due process. But now, with the 14th Amendment, the states are barred from depriving the people of the due process of law. Very important provision. And the 15th Amendment is an express protection of the right to vote without regard to race, color, or previous condition of servitude. Notice the 13th Amendment and the 14th Amendment don't really discuss race. The 15th Amendment does. There was such an express recognition that people of certain races and colors being denied the franchise that it was now enshrined in the Constitution. Okay? Let's fast forward a couple decades to 1905 and a case called Jacobson versus Massachusetts. This case involves compulsory vaccination. Now, this is not anti-vaxxer stuff, right? It's not Jenny McCarthy stuff, right? At the turn of the century, smallpox was a big deal. A smallpox epidemic in Boston could wipe out thousands of people in a fairly short time. And science at the time was a lot more not developed than it is today. How do you get a smallpox inoculation? They basically cut your arm and they put smallpox, people nodding, they put a small sample of the smallpox on your arm. And it's a weakened, diluted strain. And the hope is, well, if we give you this weakened version of it, your body will develop an immunity and you won't catch smallpox. It can also kill you, right? Again, the science back then wasn't nearly what it is today. People died from the vaccination. Also, I mean, they're basically cutting with a rusty whatever, they didn't have the sanitation. So there was a serious risk of taking this sort of vaccination. So Massachusetts said, okay, we're not going to leave this to discretion. We're going to mandate it, make a compulsory regime of vaccination. And Mr. Jacobson said, I don't want to get vaccinated. So the regime was, if you didn't get vaccinated, you had to pay a fine. So it wasn't actually a mandate, right? They weren't going to strap you to a gurney, right, and shove a needle in your arm. They said, if you don't want to pay, I think it was $5, might be off the now, but it was, not trivial. So this went to the Supreme Court. Does your right of bodily integrity, right, does your liberty interest extend so far to protect you from the state shoving a needle or a hook, whatever it is, in your arm? The court said no. The court says the authority of the state to enact this is what's commonly called the police power. Okay? And the court says, we have recognized the authority of the state to enact quarantine laws. According to settled principles, the police power of a state must be held to embrace such reasonable regulations established directly by the legislative enactment as will protect the public health and the public safety. In other words, when there's a law that the court deems reasonable, it will be upheld if it's promoting the public safety. And because the statute was designed to prevent smallpox outbreaks, the court upheld it. Now, you may not think much about Jacobson, right? You may not think much. What's the big deal? You put a little needle in your arm, maybe it'll kill you. What's the big deal? It'll keep everyone else safe. Keep that thought in mind when we come to the next case, Buck v. Bell. This is, every year I teach it, probably the hardest case to teach because the facts are so gut-wrenching. So this is Carrie Buck. I'll tell you the end of the story, and I'll tell you the beginning later. After a long legal proceeding, she had compulsory sterilization. They snipped her ovaries. Okay? They cut her tubes. Why? She was deemed feeble-minded. What? In the early 20th century, there was a very big movement known as eugenics. Eugenics, right? What is eugenics? Eugenics was the idea that we could use science to develop the promotion of the human race, to cleanse the gene pool of undesirables, And feeble-minded people should not be allowed to reproduce because they'll corrupt our blood. I see people rolling their eyes. This was, hashtag science, right? If you went to Harvard and Yale and Princeton, you'd have departments of eugenics, right? You'd have people who were advocating this at the highest ranks, presidents of the United States, presidents of universities. It's hard for me to convey how accepted this was. The Nazis may have perfected eugenics, but it sure as hell started here, right at home. So Carrie Buck was deemed feeble-minded. Why was she deemed feeble-minded? Because she was, quote, promiscuous. Why was she promiscuous? She had an illegitimate child. Why did she have an illegitimate child? She was raped. She was living at the time with her godfather, who raped her. Then when he got her pregnant, he turned over to a home, claiming that she was feeble-minded. Not only was Carrie deemed feeble-minded, the daughter, by the way, this is Mrs. John Dobbs, the husband of Mr. Dobbs, so she's actually the aunt-in-law, I'm not sure how that works, right? Basically, her husband was the father. The child, Vivian Buck, was also deemed to be an imbecile. The baby was 6 months old. Why was the baby deemed an imbecile? They gave her an IQ test. Josh, wait, what the hell is an IQ test for a 6-month-old? They can barely burp, right? What is an IQ test for a 6-month-old? I'm not joking. They took a little coin. They put it in front of her face and they moved it around. Her eyes weren't moving following the coin. It wasn't shining. So they said Vivian was an imbecile and Carrie was an imbecile. But we're not done yet. This is Carrie's mom, Emma. And the scientists here said that, aha, Emma is also an imbecile. Why? She had syphilis. Promiscuous. Okay. So here we have the situation where, this is actually Dr. Bell who ordered the sterilization, where these scientists wanted a test case. The Virginia government had enacted a law that allows for the compulsory sterilization of people that are deemed feeble-minded. And they wanted a test case. Who would be their case? Carrie. Why? Because of this family tree. Let me walk you through this, right? This is Carrie Buck. See Carrie Buck right here. This is Vivian, the 6-month-old child. And this is Emma, the mother. F, F, F. F stands for feeble-minded. They wanted to demonstrate that there were 3 generations in the same bloodline who were all feeble-minded. And the only way to prevent this bloodline from reproducing was to sterilize Carrie Buck. That if she can't reproduce, you stop this bad blood from tainting our populace. This gave rise to one of the most famous sentences in Supreme Court history by Justice Oliver Wendell Holmes. 3 generations of imbeciles are enough. Remember that from common law? 3 generations of imbeciles are enough. Who are the 3 generations? Emma, Vivian, Carrie, right there in the map. This sort of thinking is very similar to Nazi eugenics. It's German. I can't read German, maybe you can. But these were propaganda posters put out by the Nazis that allowed people, Jews, to reproduce. It's not as good as having people with Aryan features reproducing. And you have these various Nazi family trees. Indeed, the Nazis gave a special award to the Virginia scientists who enacted this policy. So this was, again, widely accepted. This line says, America needs eugenics, right? Some people are born to be a burden on the rest. Learn about heredity, and you can correct these conditions. By the way, Planned Parenthood, that's also part of this, Planned Parenthood. Eugenics. Like a tree, eugenics draws its material from many sources and organizes them into a harmonious entity. It's the self-direction of human evolution. This was, again, hashtag science, right? AF love science. This was science back in the day. The Supreme Court upheld it 8-1, and just Holmes wrote 3 generations of imbeciles are enough. There was a dissent by Justice Butler, who was the only Catholic justice. He didn't write a dissent. Some people say he dissented because of the Catholic teachings. I've actually looked into I have a student who's a priest this semester. He's very useful. The Catholic Church hadn't taken a position on sterilization quite yet, and unclear why Butler dissented. Okay. So this was Carrie Buck. She was indeed sterilized. It's not even clear if she knew what was going on. At times, they told people that they were getting surgery for their hips to relieve pressure on their hips. They didn't actually tell them what was going on. Eventually, she figured it out, and her last words were, this is not fair, this is not right. She actually went to get married once. Her husband passed away, married twice, and she passed away later on. Never had any children after Vivian. As it turns out, Vivian, the daughter, remember the 6-month-old with the little coin? She was a good student. I found a copy of her report card, right? Mostly got B's and A's. She died at a fairly young age, though. So a tragic story. Train coming through. Okay. I got a couple more cases, and we'll go to Q&A. There's another case called Skinner versus Oklahoma. Oklahoma wanted to sterilize their criminals. For getting imbeciles, people in jail should be sterilized to prevent them from reproducing. That is, if the father's a criminal, the kids will be criminals. Now, the Supreme Court reversed this sentence, but they did not overturn Buck v. Bell. Indeed, Buck v. Bell remains good law. It's probably not in your case books, but if you go read Roe v. Wade, there's a citation to Buck. Wait, what? Roe v. Wade favorably cites Buck v. Bell. Where? So, Jane Roe, Norma McCorvey, says, I have a right to control my body. Not so, says Justice Blackmun. No relation, Justice Harry Blackmun. We can sterilize if we want to, so the woman's right is not absolute of her body. So Roe cites Buck. But in Skinner, the court said, well, this law doesn't make sense. It violates equal protection, because some people are sterilized and some people are not. It makes no sense. They dodged the issue altogether. This brings us now to the case that needs no introduction, right? Roe v. Wade. This, of course, created a trimester system where, depending how far along it was, the state had various powers to restrict access to abortions. But there was one important constitutional point I want to dwell on. The 14th Amendment says you're a citizen when you're born. So if you're not yet born, are you a citizen? Do constitutional rights attach to the unborn? Does the state's police power reach those who have not yet been born? This is an issue that has no easy answer. The courts have gone back and forth on this over the last few decades. Although Roe is no longer the current law, the case is Pennsylvania. Planned Parenthood of Southeast Pennsylvania versus Casey. I like cases from here, wow. Planned Parenthood versus Casey. And also another case from my state, Whole Women's Health versus Texas. I'll do one more case, I'll go to Q&A. In 1997, we have a case, Washington versus Glucksberg. This is a case involving assisted suicide. That is, if a state wants to criminalize suicide, do they have to make an exception for those who do it voluntarily? Okay. Now, committing suicide is not a crime, because if you're dead, they can't prosecute you, right? Duh. If you have an attempted suicide, that's a crime. If you assist someone to kill themselves, that's also a crime. So the argument was that the Constitution, the Due Process Clause, guarantees a right to die with dignity, so to speak. And that doctors who assist patients in doing these procedures should be not prosecuted. The Supreme Court the Supreme Court ruled against the assisted suicide right. And they said that a right cannot be protected by the Due Process Clause unless it's deeply rooted in our history and traditions. And there simply was not a tradition of having assisted suicide. Now, in many countries in Europe, you have this, where people of all ages, it's actually even younger people, not just people with terminal diseases, but people with depression, people with various debilitating conditions at all ages, can now have a lawfully provided assisted suicide. But the Supreme Court ruled, at least under our Constitution, that's not protected. Okay. I'm going to stop here. I gave you a lot today, but I'll summarize with this point. How our law treats the human body has varied at various points in our public's history. Ultimately, though, to the extent that you want these rights to be protected or not protected, I would encourage you to look not at the courts, but the legislatures, because the courts are very poorly equipped to deal with these issues of morality that turn and change very quickly. So I'll stop here, and I welcome your questions. Thank you so much. Yes, sir. And then number 2.
Yeah, she can go first.
Go ahead, after you.
So you talk about the tension between whether something is property or a person. Now, in a lot of healthcare institutions today, you have organ donations. Where does that property self really affect, anytime you donate blood, organs, skin transfers and transplants? Can you talk a little bit about that?
Yeah, so let me answer your question in 2 parts. I also teach property, so it's a perfect question for me. The law today treats differently donations of things that grow back and things that won't, right? If you want to donate blood, actually plasma, that's what you donate, right? Semen, eggs, skin tissue, there's no problem. You can donate those fairly easily. Why? Because you create more blood, you create more plasma. But if you want to donate something that will not grow back, a kidney, right? Donate a kidney, you can live with 1 kidney. You can get paid for donating blood. I'm sure some of you made some money in college doing that. You cannot get paid for donating something that will not grow back. And this creates an important question, right? Who owns your body? If I want to sell my kidney, why can't the government let me do that? And a flip side to that is, we have a waiting list that's very long, people waiting for donations. If money was involved, would it create incentives for more people to become organ donors? The flip side to that is, do we want to commingle the sacred and the profane, right? Do we want to treat the human body as a mere commodity, the same way I can sell this bottle of water for $1? Can I sell my kidney for $5,000, right? Can you set a price for a human organ that will not grow back? Now let me answer a different question you didn't ask. What about compulsory organ donation, right? When you're dead, you're gone, when you care. So currently, I'm sure you have on your license, you can check a little box that says you want to be a donor. What if the government checks it off you by default? Meaning you have to opt out. That the normal state is that your organs belong to the government unless you say otherwise. That's a tougher question. Now I'll give you one more. Did anyone see the movie The Eternal Life of Henrietta Lacks? Henrietta Lacks, read the book? The book was much better than the movie. The movie was garbage, but the book was excellent. And this involved a poor black woman in Baltimore who was treated at the Johns Hopkins Hospital. She had these very special cells, right? Most of them, if you take a cell off my body, put it in a petri dish, it'll die in a couple days. But her cells would keep regenerating over and over again. And the doctors at that hospital basically took her cells and made billions of dollars off it. They made these long cell lines. They made a lot of money. How much did her family get? Zero, right? She passed away. She was poor, didn't have a good education, didn't know what was going on. They didn't tell her a damn thing. So even though I couldn't sell my organs, the hospitals could still profit off of them. So I gave you more questions than you asked me.
Still fine though.
You're welcome.
I'm just curious about the language in Glucksberg, and I don't know it off the top of my head, but you mentioned it, something along the lines of the liberty or the right, we're only going to recognize it if there's a long history or tradition of doing so. Do you think that sufficiently allows for science and society to evolve? If the government's going to ban something like assisted suicide or a right to die with dignity, when a development in science and just societal evolutions might want it progressively more and more for whatever reason.
So let me answer your question in 2 ways, right? So the Glucksberg test is that the court will only recognize a liberty interest under the Due Process Clause if it's deeply rooted in the nation's history and traditions and it's narrowly defined and clearly defined. That's about courts recognizing substantive due process rights. That doesn't stop the legislature from recognizing on its own. This is a problem with all law students. You only study cases, right? You never study statutes. If you want something protected, don't go to the courts. Go to Congress. Go to your state house in Harrisburg, right? As it's turned out, several states have enacted assisted suicide laws, notwithstanding Glucksberg. So even though the court turned this challenge away, private parties can keep it. Got a question? Yes, sir.
I was wondering your opinion on a case like Maryland versus King, where they allow the state to take your DNA upon arrest, and then like what the potential ramifications are of that.
So I mean, this is a case from a couple of years ago. So usually when you get arrested, the police can book you, right? And they get your fingerprints. We also do a DNA swab. Now, I'm going to ask Josh, what's the difference between a fingerprint and DNA? Well, a fingerprint will only trigger a match if you touch something, right? Fingerprints are fairly accurate science, not perfect. But DNA matches aren't that perfect, right? Let's say your cousin commits a crime, right, and leaves some blood or semen behind the crime scene, and you show up, right, and your DNA is in the database. You might be convicted on, say, a 99.7% match, but it's not you, it's your cousin. So there's a significant, I think, difference in how DNA operates versus fingerprints. But I believe the court held in that case that it was okay to collect the DNA upon the arrest. Once that DNA is in the database, it's there forever. And there are issues with corrupted blood samples, maybe imperfect match. This is, by the way, if any of you ever use 23andMe or Ancestry, don't. Because by giving your DNA to these places, the government can get it with a subpoena. They don't need a search warrant. So I actually spoke with the head of one of these companies. I was like, would you give the information to a government? He was like, no, I wasn't. Yes, you will. Right? So I will not let my DNA be sequenced by these people. No, thank you. No, thank you. I don't need to know. Thank you. Other questions? Anything else? Yes, sir.
Just based on what you were just talking about, because DNA has such a strong sort of familial implication, one person consenting necessarily implicates others indirectly. Is there any
bloodline? Yeah, exactly.
Is there any contention there?
Yeah, so I think your question is a good one, right? Because my cousin consents, that might bring it closer to me, right? They might figure out who I am through my cousin, and it's. See, my sister actually got her DNA sequence. I wasn't very happy with when she did it. I actually, but she didn't understand. But I was actually, for that exact reason, I was like, damn it, I'll still any crimes. Yeah, it's a good question. I'm not happy about it, but I got to behave now. Yeah, yes, ma'am.
So what finally sort of shut down eugenics? What was the thing that said, okay, we got to get rid of this?
What do you mean, what shut it down?
Like, why don't I learn about it in school anymore? Like,
it still happens. Oh, it still happens. So there are cases you'll read about where a judge will say to a defendant, I'll give you a choice, castration or you can serve time in jail. I've seen cases where women who have lots of children and don't care for them, the judge will say, I will let you spend more time in prison or if you undergo sterilization. What makes you think it doesn't exist anymore? I didn't say that. It doesn't exist as it was in the early 20th century. But it still exists. In fact, there's an 8th Circuit decision, 8th Circuit Court of Appeals from about 10 years ago that actually favorably cited Buffy Bell for these prison sterilization programs. So it still happens. Not like it did before. I actually had a student a couple of years ago, her aunt was, no, I guess it could have been her mother. I guess it was her aunt was from Puerto Rico, and apparently Puerto Rico was still doing this till the 70s, 1970s. I mean, it was not her mother because she wouldn't have a kid. I think it was an aunt or something. Yes, sir.
I have a question about Buck v. Bell when they were talking about the bloodline and how they said that if there were 3 generations, why were they so concerned with the mother if she had already had a child? Like if that's the way that they're thinking.
It was a setup, right?
Yeah.
This was what's called a test case. They just wanted the facts to fit a narrative, and they found the perfect person because they could say the mother, the daughter, the granddaughter. We got to stop this bloodline, right? Because I guess when the Vivian grew up, they'd have to sterilize her too, and she came child rearing age. I think that was next.
Okay.
Yeah. Anything else? No? Thank you all so much.